number 28, matter of MHLS versus Delaney. Counsel?
Good afternoon, Your Honors. May it please the Court, I'm Shannon Stockwell of the Mental Hygiene Legal Service on behalf of Petitioner Appellant Olivia C.C. I would respectfully request 2 minutes time rebuttal.
Yes, sir, you have 2 minutes.
The issue on this appeal is whether a developmentally disabled child can sue the state to enforce her right to receive approved Medicaid waiver services in order to obtain her discharge from a hospital emergency room where she was held for 35 days. Plaintiff urges the court to reverse the appellate division's opinion in order below, dismiss or deny the state's motion to dismiss, and remand to Supreme Court on the reinstated petition. The state clearly has obligations to people with developmental disabilities participating in the Medicaid waiver. In particular, under Mental Hygiene Law 13.07, the state is required to provide services including care and treatment, and to ensure that such services are of high quality and effectiveness, and that the personal and civil rights of persons receiving such services
Counsel?
are protected.
Did counsel below, on behalf of the petitioner, ask that the matter be dismissed?
I don't know that there was a formal motion to dismiss, but in their papers they indicated that there was a failure to state a claim, and that's how Supreme Court treated the...
But didn't the court initially have a conditional order? And the court was going to hold the matter in abeyance, and then counsel came in and asked for dismissal?
I have to confess it was a little unclear how we got to dismissal, but certainly the Supreme Court entered an order denying all of petitioner's claims on the merits, and we took an appeal accordingly. And throughout the appellate process, the state took the position that we failed to state a claim upon which relief could be granted. So we would submit that the appellate division wrongfully failed to employ the typical motion to dismiss analysis, granting us every favorable inference and taking our allegations as true. Moving on, a major problem with the appellate division's decision below is that the court found that there's no private right of action under the Medicaid reasonable promptness provision. 6 circuits court of appeal have all determined that such provision is privately enforceable, unanimous.
Counsel, I know there's one, and I think it's the Sixth Circuit that came later, but at least 5 of those are before Armstrong, right? Here.
Oh, sorry.
Okay. It's a hard one. But 5 of those cases, I think, are before Armstrong. The Sixth Circuit, I think, comes out after Armstrong, but it doesn't really address it. And it seems there's language in Armstrong that makes your argument more difficult.
I think that there's been a tightening up with Armstrong, the private rights of action under the Medicaid Act, various provisions in the Medicaid Act, but there are 80 of them. And Armstrong dealt with the equal access provision, which is completely distinct from the reasonable promptness provision. I think that the Supreme Court really had a hard time. The majority of the Supreme Court felt that the language in the equal access provision, Medicaid Act, was judicially unadministratable because it was judgment-related. I think that the question of whether services are delivered to a person with reasonable promptness certainly is something that is within the wheelhouse of a judge. And the Centers for Medicare and Medicaid Services, in fact, had outlined a 5-factor test in its Olmstead Update number 4 that really simplifies the matter. And I would submit that certainly Waskell is the only case since Armstrong where a circuit court has held that reasonable promptness provision is privately enforceable. But there's no reason for the appellate division to deviate from that, and certainly no under the circumstances of this case, we're pre-trial for the court to put itself out there and find that is not privately enforceable made no sense under the circumstances, and it's really an outlier. And the state has urged the court to essentially abstain from hearing the issue because it's subject to dispute in the Circuit's Court of Appeal, but I submit that that's not true. There's unanimous authority at this point.
Counsel, the appellate division in its writing seems to suggest that Armstrong sort of changed the game on this private right of action. Is it your position that we're still using the same set of standards that were articulated in Gonzaga and the cases before that, or does Armstrong even add anything new to the analysis, is what I'm asking?
I think it was Armstrong flowed from Gonzaga, and there's certainly, like I said earlier, been a kind of a restricting of private rights of action in Supreme Court jurisprudence.
So is it the unadministratability of the statute that still controls, or is it more than that?
That's the law of Armstrong. And I think that's the fact. And as with the plaintiffs in Armstrong, our client sought relief in equity, so we're not subject to statutory requirement. And the court's reasoning in Armstrong was that in equity, the two issues that courts need to look at are whether there was a intent to restrict relief, and that the Centers for Medicare and Medicaid Services can hold back money from the states if they violate a provision. But also, the court said that wasn't the end of the ballgame, so to speak, that there was also the question of whether the provision is judicially unadministratable, which I would submit here is clearly not the case. And I would actually submit that the equal access provision is administratable as well, but that's neither here nor there.
That's another case.
Yeah, certainly. I do want to move on. In the interest of time, I want to get into the ADA claims as well. The state has an obligation to ensure that services are delivered to Medicaid waiver recipients in the most integrated setting. Clearly, that didn't happen here. My client she lived in a hospital emergency room for 35 days. It almost speaks for itself. But also the question that the state employs methods of administration that subject people like my client to discrimination. In this case, they've placed
That's count 7, I think, and I don't actually understand that. So what is the discrimination?
It's Olmstead, Your Honor. She was subjected to unnecessary isolation in the hospital ER, where she should have been living in the community receiving services.
That sounds like the integration claim, no?
That is the integration.
Oh, so I'm asking that, the integration claim is count 6.
Yeah, they're kind of tied together. I mean, the courts, the state's reliance on the private sector to deliver services to individuals is an arrangement that results in discrimination to people like my client, and so that was they're tied together in a sense.
So I'm not an expert on the ADA, but discrimination to me sounds like as compared to some other group.
Well, it flows from Olmstead, the 1999 U.S. Supreme Court decision where the court held that unjustified isolation of disabled folks is discrimination. And she was, in this case, my client was isolated in a hospital ER when she had been approved for community rehabilitation and respite services that would allow her to live in the community with her family, with supports in place.
So, counsel, if I can interrupt you on that point, I'm on the screen.
Sure.
Is your point that she is treated differently from adults who would have the same types of disabilities, or other children with those disabilities who might have otherwise had easier access to the services?
Well, certainly she's treated differently from adults because the state of New York, through its both through state operations and through its partnerships with the non-for-profit sector, certainly do provide respite and community rehabilitation services to adults. So she's treated differently from adults in that respect.
But does that state an ADA claim?
It certainly does. It's a methods of administration that it's actually comparability violation under the Medicaid Act as well. The state is required to treat all service recipients in the waiver the same way. They have to be able to access all the services on the same level. And
That's a Medicaid requirement.
That is, Your Honor.
So counsel, what relief are you looking for?
Under the circumstances, we're seeking reversal of the appellate division's decision, denial of the state's motion to dismiss, and remand to Supreme Court on the reinstated petition. There's many factual issues in this case that needed to be fleshed out before we could move forward. And it's completely improper for the courts below to not employ the traditional standard of review on a motion to dismiss. And we would submit that if we had been able to engage in fact-finding, we could have articulated a claim for appropriate injunctive relief.
That's actually something that puzzled me a little bit about, or maybe a lot actually, about the appellate division decision, which is, I understood your complaint and your argument now to be asking for a chance to prove a variety of things, not that you've proven them. And I read the appellate division decision, not all of it, but part of it, to be treating this as if it was a mandamus to compel the government to do very specific things, which those two things don't seem to me to mesh. That
Yeah.
You couldn't get to the point of even thinking about what the relief is unless you had actually proven something.
That's right. There's no facts in the case at this point. The Supreme Court held that our claims could not stand, and the appellate division affirmed on the merits. So we had, and we never treated this as a mandamus to compel. We had argued that the state's failure to provide these services to my client were arbitrary, capricious, and contrary to law. That was clearly.
Wait, but counsel, again, I'm on the screen. I just want to clarify this. I understood your argument to be that the state, because of the choices it's made in this particular case, and there are other children who seem to fall within this same unfortunate situation of these extensive delays, and you have the hospitals saying, and they end up in the ER and wards where they shouldn't be placed, and they're not getting their services. In any event, I understood your relief, because I'm very interested in this, to be we want them to provide the services that they have already determined she should receive and that they agree that she should receive. Am I misunderstanding what you were arguing?
No, that's correct. It's our position. The state has an affirmative duty. Once they've agreed to participate in the Medicaid program, obligations fall upon the state to ensure that those services are provided. So that is the argument. They have to ensure that the services are provided. You know, the question of whether it's the not-for-profit sector that must, provide those services versus the state is a question.
So then if I can just follow through on this. So then if I'm understanding your argument isn't you must do it exactly the way we say you must do it. You must provide those services. You're the state. You've got the discretion of the commissioners. You figure out how to do it, but you can't hold her for 5 weeks in an ER without providing those services. Am I understanding you?
That's correct, but I would also add that it was our position that the courts below could have granted injunctive relief where the state failed to do what it was supposed to do to provide those services. But
that's what I'm saying. Your demand has always been provide the services that have already been identified by the commissioner that she should be receiving.
Yeah, these are existing services.
It's not that you were arguing. Yes, I just want to clarify this point. You did not go to court to say they have determined the wrong sets of services to provide to her.
No, there's no
correct?
There's no if that were the case, if there was a service denial, an application that was
Yes.
denied, then the fair hearing process would kick in. That's not the case.
Right, right. Yes, no, I understood your briefing. This was not about a fair hearing. It was something else that you were seeking to do. And your issue is it just takes them too long to do that. And in the interim, right, you were claiming that she suffered as a consequence because she wasn't receiving the services that everyone agrees she's entitled to.
That's precisely right.
Okay.
And I would also add, finally, just getting back to the fundamental alteration defense, that it wasn't affirmatively pled as a defense at the Supreme Court level. It was interposed at the appellate level, and clearly fundamental alteration with respect to the ADA claims is an affirmative defense, been recognized by basically all the courts that have dealt with it, including the Department of Justice. And under the circumstances, it should not have.
Well, counsel, again, I'm on the screen. You're saying there's no factual dispute, or, I'm sorry, you are saying there's something factual to be developed in a record on that defense?
Well, the state needs to prove that our request that she be provided with these services would result in a fundamental alteration to its program, essentially that it's a new service, and it's not.
I understand, but since everybody agrees to what, that was sort of the prior line of inquiry here, since you're saying there's no dispute about what the services are, why couldn't they have made this argument, and why couldn't the appellate division have resolved it? Again, I'm not sure I'm understanding what's the discovery, if everybody's agreeing to what the services are.
Well, the state's never agreed that they have an obligation to ensure that the services must be provided to her initially, and I think that if they're asserting that this is a new service, essentially that requiring the state, if there's no mechanism for the private sector to provide these services, that essentially requiring the state to do so as a provider of last resort would be essentially a new service. That's the defense that they would have needed to prove.
But you did not argue that the state had to provide this. That wasn't your argument, am I correct?
It's always been our position that the state should have arranged for the services to be provided. But the question is in these fast-moving fact patterns where the private sector is unwilling or unable to provide the services, should the state be required to reallocate some resources in order to enable the Medicaid recipient to receive those services? That's a question that would have needed to have been fleshed out through fact-finding at the Supreme Court level.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court, Laura Etlinger for the state respondents. The
With
appellate
respect to the motion to dismiss, was there a formal motion to dismiss here?
No, this was brought primarily as a summary proceeding pursuant to Article 70 of the CPLR and Article...
But when you say primarily, it is not entirely a summary proceeding.
They included federal statutory causes of action, but I think the way it was really litigated in Supreme Court was as a summary proceeding seeking to resolve the situation that was at hand. And that was really everybody's focus. And in response to your earlier question, I would just note at record page 147, which is the transcript, I'm not sure if this is what Your Honor was getting at, the Supreme Court offered to keep the proceeding open.
The court did. The court wanted to make sure this particular child was taken care of, and then the parties the petitioner said, no, if
Yes.
there's a problem, I'll bring another action.
Yes, exactly. The question before the court is whether any of these three statutory provisions provide a basis for relief in this case. And the answer...
Counsel, if I can interrupt you, I'm on the screen. Hello, good afternoon.
Yes.
So I just want to make clear, do you agree that, as opposing counsel asserted in response to me, that there is no challenge to what the services themselves are? That the commissioner has decided they're not challenging that. They just say, okay, so provide those services. And their whole... what they have gone into court to seek is for you to do it because it just took too long. Do you agree that there's not a dispute over the services themselves? Forget about how they're provided, but that the services themselves.
I agree to a large extent. I think that they were, a basis for their claim was that petitioner had been approved for particular home and community-based services, waiver services. They were approved, funding, additional hours were approved for them, care coordination was provided to assist the family in locating appropriate providers. There happened to be particular circumstances in this case that made it difficult. We don't know what happened with the providers that were previously serving this petitioner in her home. But for whatever particular circumstances in this case, partly in the fact that they lived in the North Country and there just are fewer providers of all services in a more sparsely populated region, nobody who was specially trained for this particular petitioner's service needs was immediately available. But I want to make it clear, two things. One, OPWDD, this is not a case where OPWDD did nothing in response to the situation. First of all, OPWDD does have programs in place that seek to address this particular type of problem on the front end by seeking to avoid, very prudently, crisis placements in the first place. And
Counsel, can I ask you, because I think in correspondence with the court, you indicated that there were additional crisis intervention resources being made available so that this sort of thing wouldn't happen again. Where do we stand with those additional services? Go ahead.
I'm sorry. They are actually now fully available throughout the entire state, including Region 2. There was some delay in getting the services available in that region, and they, as we outlined in our brief, are highly successful.
Do you have any statistical information about the rates of hospitalization or long-term hospitalization having gone down?
Exactly. And those statistics, the most recent ones are available online from the 2021 fiscal year, and the same successful rates continue to occur.
How, if at all, counsel, might the pandemic make it a little bit uncertain that those statistics can really be based on the services? Is there some disaggregation that might be helpful?
I'm not aware of any further statistical analysis that has been made with respect to those. What I can say about the pandemic is that the challenge facing the system right now is, as it is in many, many fields, a shortage of staffing. And the state has recognized that that is a serious concern for the entire service system now, and has, through federal funding, designated $1.5 billion to work toward retention and recruitment for direct care service workers for people who work with developmentally disabled children. So this is not a situation where the state is ignoring the problems at hand.
Counsel, I appreciate that, but the question here, I think, is whether these variously pleaded counts in the complaint state claims or don't state claims, and everything you said, I think, would, if true, would entitle you to win. But it's facts that aren't in our record, and if there is any of these that is a viable claim, just stated as a claim, isn't the right thing to do to send you back to put that evidence in the record?
Well, I have two responses. First, because this was litigated primarily as a summary proceeding, the Supreme Court did decide the claims on the merits and rejected them on the merits. And we believe the appellate division, in the way it analyzed it, I think the request...
But what about the fact that it appears that the AD asserted an affirmative defense that you did not plead?
I think it was simply clear from the record, and this goes back to what relief petitioners were really seeking in this case. Although they were making an argument that the approved services weren't available to her because there was no appropriate provider suitable for her at that moment, they were also clearly indicating again and again in their memo of law at page 91 of the record and in their briefing that the state had an obligation to operate facilities directly or provide services directly if there was a situation where the...
So my question is, did you assert the affirmative defense that the AD...
we didn't assert it specifically as an objection in point of law as an affirmative defense
But
in
are
our
you saying
answer.
that nevertheless
But
it was okay?
It was raised before Supreme Court in the briefing in the sense that all the parties agreed that what petitioner was seeking was an alteration to the system so that if there was ever a situation where services weren't immediately available, the state would step in and provide those services to fill any gap in the private sector. And that is a fundamental alteration.
Counsel, could you address the private right of action and the effect of Armstrong?
Yes, absolutely. I think What Armstrong makes clear is not only that the Gonzaga direction, that there must be an unambiguously implied right of action, is the correct test, and that the court should not be focusing primarily, as many of the circuits did in this case, on the blessing factors, including whether there is an intended beneficiary, that's the wrong focus. Armstrong also made the point very strongly that in these spending clause statutes, what you have involved is a contract between the state and the federal government. And it is the provisions that are telling the federal government, telling the state what is required for federal approval. And that without clear, unambiguous language evidencing a congressional intent to create a cause of action for private litigants, where there are other enforcement mechanisms, as there are here, not only the federal administrative enforcement, but not for this particular claim in particular, but for other types of reasonable promptness claims, there is an administrative remedy. And I think for all those reasons, the appellate division was correct that there is no private right of action. On that point,
But counsel, with respect to that spending provision argument, or spending bill argument that you make, in the words of Justice, then Judge Alito 20 years ago in the Sabri case, it's not unreasonable to predict that that's what the Supreme Court's going to do, but they haven't actually done that. They haven't said where it's a spending bill, it's essentially contractual and there is no private right of action. Is there a holding out there that confirms what you're now putting forth?
Well, I think there is, that is a majority of the analysis in the Armstrong case, both in the majority opinion, which notes that this is a situation where the federal government is approving what the state is doing, and in the plurality opinion in that decision. And I would just point out, too, that the appellate division is not the sole outlier on this determination. In the Seventh Circuit, where the circuit itself has assumed for purposes of deciding and rejecting claims under the reasonable promptness provision, district courts in that circuit have now agreed with the analysis of the appellate division and held that there is no private right of action. But the court need not wade into that issue. If it chooses not to, it can affirm dismissal of the Medicaid Act on the merits. The regulation that implements the reasonable promptness provision makes very clear that what is at issue in that provision is delay caused by the agency's administration of the Medicaid program. And that is not what the claim is here. There is nothing in the actual administration of the approved waiver program that caused any delay here. The delay was caused because providers weren't available. And there's nothing in the Medicaid Act or the Medicaid waiver here that guaranteed that in every situation that could possibly arise, which are unfortunate situations, certainly OPWDD is very concerned when any situation like this arises. And they do what they did in this case. They jump into action, make concerted efforts to try and locate any interim relief that might be available. But sometimes, the system isn't perfect, but there is a comprehensive system in place. To the extent it involves Medicaid, it was approved by the federal government. And for those...
But counsel, if I can interrupt you there, I'm not going to disagree with what you said in part, but the standard is reasonableness, right? And 5 weeks may not appear reasonable, whereas maybe 5 days would, right?
But
So it's about the extent of the delay.
well, I don't...
You may be making best effort. No, I'm not going to challenge any question about best efforts. Judge Wilson's already pointed out that some of this, of course, would have been decided on the merits because you haven't really developed the record. But it is 5 weeks. It's a reasonableness standard, and that is exactly what courts do. They figure out whether or not something is reasonable under the circumstances.
But the reasonable, what I would disagree with is that the reasonable promptness provision requires that services be provided for any conceivable circumstance that might cause delay, that the state is responsible for that delay under the statutory provision. The statute, as made clear by the implementing regulation, is talking about how the system is administered, how the existing approved system is implemented.
Yes, but in this case, a system that relies on entities that are not available really pushes the button. I don't think this is your strongest argument, let me just say. I mean, you can continue to make it, but it's a very odd argument to make that, you know, we threw up you did a lot of work, but look, it's just the region and the circumstances here just made this go on and on for 5 weeks.
I would just point out that these are all very unique circumstances, and what...
Well, you've got, again, that is a very fact-laden assertion, and I don't think you can make that at this stage.
Well,
I mean, you've got the hospital saying you've still got problems.
Well, this was not brought as a class action, I would just remind the
Well, I understand that.
But the cases involving the reasonable promptness provision make clear that what they're really talking about is things like requiring too much of a reserve so that funding is not actually available for the services that have been approved, or things like having a waiting list in a waiver program, even though there are unfilled waiver slots. That involves administration of the program. What we're talking about here is how is the program in the entire system in the state devised in the first place.
Yeah, but obviously, since you've, in your briefing and today asserted that there aren't these other ways of addressing the issues, you yourselves, I mean, internally, the state has recognized that there was a problem in what they came up with. I mean,
No,
I don't think you can walk back from that. It might still not violate the provision, but I don't think you can walk away from that.
I think the state has certainly taken steps to address a need, and it's always trying to be flexible to address whatever the need is that arises. That's why right now they're addressing the shortage in staffing. But the implication of petitioners' claims is really that this would not have occurred and could be solved in the future if the state operated a program that had empty beds ready and waiting for any particular crisis situation, each of which is very unique, might arise. Or that there are state staff readily available to go on a moment's notice to anywhere in the state to provide direct at-home services if in that particular situation suitable providers are not immediately available. And we would submit that's not a reasonable solution to this problem, because for the very reason that each individual will have particular and specialized service needs, in particular in cases like this, where you have an individual with not only developmental disabilities, but also mental health and behavioral conditions that make it a complex service need. And even if the state had a dedicated respite facility for children, which, whether this is, fiscally feasible, we're not even addressing here. But if it did, and it had, 5 empty beds that it just kept and staff waiting for a crisis situation to occur, that couldn't guarantee that a particular individual who needed a placement, that would be an appropriate placement for that individual. They may have particular service needs that need certain staff to client ratios that might not be set up in that facility. They may have particular service needs for specially trained staff that might not be in that facility. So I think the idea that there is some perfect system out there that the state has failed to create that would avoid every crisis situation simply isn't realistic.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you, Your Honor. I'll be brief. It was never our position that the state needed to create buildings and staff them and be ready at a moment's notice to save children in crisis. That's nowhere in our pleadings, and I take issue with that. We sought declaratory and injunctive relief below that we stated several causes of action under the Mental Hygiene Law, the Medicaid Act, and the Americans with Disabilities Act, and we were seeking preliminary and injunctive relief, but not building buildings by the state. I wanted to touch on a couple of things. The state touched on the fact that they didn't do nothing in the context of this case. What they did was they provided referrals to non-existent services and offered to pay for those non-existent services. So that's essentially nothing as far as I'm concerned. And they have an obligation pursuant to a 2010 amendment to the Medicaid Act. Medical assistance means paying for services, but also the services themselves. Clearly, they have an obligation under the Medicaid Act.
So what is the remedy? Do you concede that the only solution to that issue is for the state to step in and provide those services themselves?
No, I wouldn't concede that. I think that we need fact-finding in the case to determine the extent of the state's resources, but also the extent of the resources in the private sector and the ability of the state to reallocate those resources and incentivize the private sector to provide services to individuals.
I'm sorry, what would that be? You would get some kind of declaratory relief to reallocate resources?
No, we were seeking an injunctive relief. But
So what would happen there?
The state, I think that in cases where the Department of Justice has been involved, they've found violations similar to these, and they said to the states, look, you have all this money, billions of dollars through the Medicaid program. You need to move some of that stuff around and potentially incentivize the private sector. If that's your program.
But that's the Department of Justice enforcing a federal statute in terms of spending. But we're going to have a trial judge in this part of New York State and make that determination? Is that what would happen?
Your Honor, it would probably be the extreme end of things.
But that's what you're asking for. What would be the non-extreme? And
realistically, we'd have to see how the fact-finding played out, because I don't know what the facts are in this case.
But doesn't that type of remedy and potential really go to whether or not this claim should go forward at all? Because if there's the potential for you to have a Supreme Court judge or a trial judge in this case reallocating state resources under Medicaid, would it be some kind of statewide plan?
I think that I'm not certain of the type of relief that Supreme Court would come up with. That would be, like I said, more of an extreme option. It's difficult to envision what the injunctive relief would look like under the circumstances. The injunctive relief could look as simple as, State of New York, you have obligations under the Medicaid plan. Clearly, there's a violation here. You need to fix the problem. Prepare a plan for us or for
Or you
me.
might get a declaration and no injunction at all. Is that possible? I mean, you sought declaratory relief as well.
Yeah, well, it's absolutely. I think we have to have the declaratory findings first before we get to injunctive relief.
But the court may, for reasons related to injunctive relief, not relating to the merits, may decline to give you injunctive.
That could certainly be the case. Yeah, there's severable. That is correct, Your Honor.
Thank you, counsel.
Thank you.